Senator, I responded to Senator Kennedy's questions based on a publicly filed document that described the Attorney General as a...
Did you talk to Stephen Miller?
I'm not going to describe the participants in conversations.
So you won't answer that question?
No, I will not, Senator.
Why?
Because it is not appropriate for me to discuss...
It is appropriate for you to tell us whom you consulted before taking action on behalf of the United States of America. You have no basis to avoid that question, Mr. Bove.
Respectfully, Senator, I'm answering that question in a manner similar to several nominees before me, including Judge Katzen.
Did you talk to anyone in the White House, including the President, about dismissal of the Adams charges before the February 10th memorandum?
I respectfully refer you back to my answer, Senator.
I am absolutely flabbergasted.
What happens when a judicial nominee for one of the highest courts in the land outright refuses to answer basic questions about his conduct, about his conversations, and about the political games being played inside the Department of Justice? That's exactly what unfolded when Trump's Court of Appeals nominee Emil Bove sat before the Senate Judiciary Committee and went toe-to-toe with Senator Richard Blumenthal. It was a shocking moment, not because Bove slipped up, but because he stood firm, refusing to play the senator's game of entrapment and political theater. And the reaction? Outrage, anger, and a desperate attempt by Democrats to paint him as evasive, corrupt, and compromised. But here's the question every American should be asking. Was Bove protecting the integrity of the judicial process, or was he hiding something? And more importantly, why is it always the same senators who preach transparency but weaponize these hearings for partisan attacks? Tonight, we break it down. Welcome to America Viewpoint, where we speak the truth, defend our freedoms, and fight for the values that made this nation great. No censorship, no woke spin, just bold, unfiltered commentary from real Americans who love this country. If you're tired of the lies and ready to stand for faith, family, and freedom, hit that like button, subscribe, and ring the Liberty Bell, because this is where the fight begins.
Privilege? First, this committee and Congress have never accepted that kind of assertion as a basis to evade questioning in this kind of confirmation hearing. But I'd like to point out also that this witness has no right to invoke that privilege. It's a privilege for the government of the United States to invoke. Now, I notice that the Deputy Attorney General is sitting right behind the witness. I didn't hear the Deputy Attorney General invoke this privilege on behalf of the government of the United States. And I might point out also that the witness is invoking it selectively. When he wants to answer the question, no privilege. When he wants to avoid answering the question, he says he's not at liberty to answer it. We've never accepted that kind of tactic on the part of a witness. Yes, nominees have sometimes said they can't comment on a case or an issue because it may come before them as a judge. But this kind of selective invoking of a privilege smacks of evasion and defiance, and I think reflects on us as a committee if we accept it in this context, Mr. Chairman. So I hope that the witness may be instructed to answer these questions, or we can have a resolution somehow on the legitimacy of this kind of privilege and ask the witness to come back. Let me begin my questioning.
Mr. Chairman, I think the clock was started on Senator Blumenthal while he made his point of order. It might be a courtesy to allow it to be. Thank you. There it is.
I hadn't noticed that, Mr. Chairman, but I thank Senator Whitehouse for pointing it out. Thank you.
Let me say in the future,
Mr. Bove,
White House made very clear the issues you're bringing up, and I said I'm willing to discuss them. But
thank you.
We can't take the time of this committee to hear a repeat of everything from every member that would disagree with what I said in my opening statement.
I appreciate
Senator
your
Blumenthal.
point, Mr. Chairman. I'll begin my questioning. Mr. Bove, you responded to Senator Kennedy's questions about who was consulted about the dismissal of charges against Mr. Adams. Did you ever talk to Stephen Miller before you filed the memorandum on February 10th ordering the dismissal of the Adams charges?
Senator, I responded to Senator Kennedy's questions based on a publicly filed document that described the Attorney General as a
Did you talk to Stephen Miller?
I'm not going to describe the participants in conversations.
So you won't answer that question?
No, I will not, Senator.
Why?
Because it is not appropriate for me to discuss.
It is appropriate for you to tell us whom you consulted before taking action on behalf of the United States of America. You have no basis to avoid that question, Mr. Bove.
Respectfully, Senator, I'm answering that question in a manner similar to several nominees before me, including Judge Katzen.
Did you talk to anyone in the White House, including the President, about dismissal of the Adams charges before the February 10th memorandum?
I respectfully refer you back to my answer, Senator.
I am absolutely flabbergasted that you would come before this committee and refuse to tell us basic facts about a case that is at the core of the challenges to the appearance of impropriety that should disqualify you. You have the opportunity to clear the air, to come clean with the American people as well as this committee, and you are evading and avoiding these questions.
Senator, if you have a question about the position that I took in public with respect to the Mayor Adams case, I'm happy to address it, and I've addressed several today.
Well, I have asked you a question that bears on the appearance of impropriety. Let me go on. Mr. Bove, in court, you represented, first, that there was no quid pro quo, but you said that the decision, even if there were a quid pro quo, was unreviewable by the court. Do you stand by that?
I don't think that's what I said, Senator, because it's not consistent with the rule, which explicitly provides.
Well, you said it not only once, but you said it a number of times, and the judge observed, Judge Ho said, that your position was, quote, fundamentally incompatible with the basic promise of equal justice under law. That's what he said about your position, that the decision to dismiss these charges was unreviewable. Do you stand by that assertion?
I never made that assertion, and the judge granted the motion, Senator.
He granted the motion, but he disagreed with your premise that it was unreviewable. Let me ask you, are decisions to dismiss cases, as with that one, unreviewable?
The text of Rule 48 requires, in the instances presented by the Adams case, that dismissal only be provided for with leave of the court. That's as near a quote as I can give you, and the entire brief that I submitted acknowledged that point because we were seeking the leave.
Mr. Bove, I am concerned about the quid pro quo that the judge concluded had been done. In fact, he said everything here smacks of a bargain. Everything here smacks of a bargain. But the quid pro quo that really concerns me is the one that brings you here today. You were virtually the only attorney in the Department of Justice willing to go to court and make a claim that career prosecutors said violated their basic standard of ethics. And the quid pro quo was a nomination to the Court of Appeals. That's the appearance that the American people can take away from your sitting before us with that nomination. And I think it does grave damage to respect for the rule of law, notwithstanding your assertions about your adherence to it, for you to be here as a result of that stand by you. Let me ask you about a separate issue, the firing of prosecutors and investigators who were involved in the January 6th prosecutions. You were involved in purging prosecutors who, in good faith and an exercise of their prosecutorial prosecutorial judgment. They went to court, they brought charges, you purged them. Isn't that correct?
I don't agree with the use of the word purged, Senator.
Well, you fired them.
I authorized the termination of probationary employees at that U.S. Attorney's office, yes.
Because they prosecuted the January 6th rioters.
No, because I was concerned about efforts in the prior administration to embed those prosecutors as permanent employees at the U.S. Attorney's office.
And you also fired the FBI investigators involved in the January 6th prosecution, correct?
No, that's not accurate.
You worked with Director Patel in firing them, correct?
No, that's not accurate.
Senator Smith.
Thank you, Mr. Chairman. I'm going to pivot away from the Democrats' fake outrage.
The hearing began with fireworks. Senator Sheldon Whitehouse and Senator Richard Blumenthal zeroed in on a so-called deliberative process privilege. They argued Emil Bove had no right to invoke it because it belongs to the government, not the individual witness. In other words, they accused him of cherry-picking when to answer questions and when to stay silent. Now, pause for a second. Isn't it ironic? These are the same senators who will bend over backwards to shield unelected bureaucrats from scrutiny, who protect executive privilege when it suits them, and who constantly hide behind closed-door deals. Yet suddenly, when it's a Trump nominee, the outrage is deafening. Blumenthal accused Bove of being evasive, of smacking of defiance. But let's be clear, what Bove did was no different than what countless nominees before him have done. Judge Katzmann, Judge Roberts, even Justice Kagan, all refused to answer certain lines of questioning on grounds of propriety. But here, because it involves a Trump-era decision, suddenly it's scandalous? Give me a break. The heart of the questioning centered on one case, the dismissal of charges against Mayor Adams. Blumenthal pressed Bove relentlessly. Did you talk to Stephen Miller? Did you talk to the president? Did you talk to anyone in the White House before filing your February 10th memorandum? And Bove? He stood his ground. I will not answer that question, Senator. Now, the mainstream spin is he's hiding something. But step back. If you're a government attorney, do you go to a Senate hearing and casually reveal every private consultation, every internal discussion, every White House conversation? No. That would undermine not just attorney-client privilege, but the very structure of executive deliberation. Blumenthal thundered, accusing Bove of evading, of disrespecting the committee, even of disqualifying himself. But what he really wanted was a soundbite. He wanted Emil Bove to say, "Yes, I talked to Stephen Miller so the media could run headlines about Trump cronies pulling the strings." It was a trap, and Bove refused to step into it. Here's where the Democrats try to land their knockout punch. They pointed to Judge James Ho, who said Bove's position in court was fundamentally incompatible with the promise of equal justice under law. They claimed the whole dismissal smacked of a bargain. In other words, a quid pro quo. Then Blumenthal went further, accusing Bove's very nomination of being the quid pro quo. You were the only attorney willing to make this ethically questionable argument, and now you're rewarded with a Court of Appeals nomination. Think about that. This wasn't a question. This was an accusation, an insinuation that Bove's entire career advancement was corrupt. And let's be honest, that's not oversight. That's character assassination dressed up as constitutional duty. Where's the accountability for senators who use their platforms to smear nominees without evidence? Where's the respect for due process when the presumption of guilt replaces the presumption of innocence? That's not leadership. That's politics at its ugliest. Bove responded with calm precision. He pointed to Rule 48 of Federal Criminal Procedure, which requires court approval to dismiss charges. He emphasized that his brief explicitly sought the court's leave, acknowledging the rule's requirement. So here's the question. If the judge granted the dismissal, even while disagreeing with some of the arguments, doesn't that mean the process worked? Doesn't that mean the court applied its oversight and still approved the motion? But Blumenthal wasn't interested in the rule of law being applied. He was interested in theatrics, in painting Bove as a corrupt insider. Yet the fact remains, the court sided with Bove's filing. Blumenthal then pivoted to January 6th. He accused Bove of purging prosecutors and FBI investigators who pursued cases against the rioters. Bove denied the word purged but admitted authorizing the termination of probationary employees. His reasoning? He claimed the prior administration tried to embed prosecutors permanently, and he acted to maintain fairness in staffing. Now, let's be clear. Was it messy? Yes. Was it politically charged? Absolutely. But was it within his authority? Yes. And once again, Bove stood firm. He denied firing FBI investigators. He denied coordinating with Director Patel. And yet, no matter what he said, the narrative was already written. To the left, anyone who touched January 6 prosecutions and didn't play their partisan tune is guilty. Guilty until proven innocent. And even if proven innocent, still guilty. This hearing wasn't just about Emil Bove. It was about something far bigger. It was about whether judicial nominees can survive the gauntlet of politically motivated attacks. It was about whether Democrats can turn every confirmation into a circus to delegitimize conservative nominees. Ask yourself, why is it always Trump's nominees who are treated like criminals on trial? Why is it that the same senators who rubber-stamp progressive activists for lifetime seats suddenly demand total transparency, total confession, and total submission from anyone tied to Trump? Because this isn't about the law. It's about control. It's about a permanent political class in Washington that wants to decide who's allowed on the bench and who isn't, not based on qualifications, but on ideology. Now, let me be clear. This isn't about defending Emil Bove as a perfect man or perfect lawyer. This is about defending principles. The principle that nominees deserve fair treatment. The principle that the Senate's role is advice and consent, not smear and destroy. The principle that the rule of law should never be weaponized for political gain. And for every American watching, this should raise alarms. Because if they can do this to a judicial nominee, if they can twist privilege into evasion, twist arguments into quid pro quos, twist staffing decisions into purges, what can't they do? Where's the accountability? Where's the respect for the Constitution? Where's the commitment to equal justice? This is why we fight. This is why channels like America Viewpoint exist. Because the American people are sick and tired of the double standards. Sick and tired of seeing their values trampled while the political elite play power games. We believe in free speech. We believe in due process. We believe in the Constitution as written, not as twisted by lawyers in Washington to fit their agenda. And we believe in calling out hypocrisy wherever it appears. Because at the end of the day, this isn't about left versus right. It's about liberty versus control. It's about whether the American people still have a government that serves them or whether they're ruled by a political class that serves only itself. This was a shocking hearing, not because Emil Bove slipped, but because senators once again showed how far they'll go to turn confirmation hearings into partisan theater. And that's why we have to keep fighting. This is America Viewpoint, where we don't whisper, we roar. We stand tall, speak loud, and never back down from defending truth and liberty. If this message fired you up, smash that like button, hit subscribe, and turn on notifications, because the fight for America doesn't end when the video does. Until next time, stay strong, stay free, and may God bless the United States of America.